fix you up, make everything much smoother again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and heart so true. I'll fix you up, Daniel, I'll fix you up. The connections might be tangled, the power source has lost its spark, but every wire tells a story, and I can mend what's torn apart. From sunrise till dawn, I'll be here waiting. From sunrise till dawn, I'll never stop. I'll fix you up, make everything look smooth again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and heart so true. I'll fix you up, Daniel, I'll fix you up. When the current isn't flowing, when the signals disappear, I'll be here with tools and patience, make the static crystal clear. Every cable, every circuit, every problem that you bring, I'll restore what time has broken, make the whole world sing. So don't you worry about tomorrow, don't you stress about today. I've got maintenance for your troubles, and I'll chase them all away. I'll fix you up, make everything run smooth again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and heart so true. I'll fix you up, Daniel, I'll fix you up. Hey, Daniel, everything's good as new. Hey, Daniel, I'll fix you up for you.
Excuse me. Welcome to the show. I am your host, Daniel, and today is Judge Robert McBurney. I think it's Robert McBurney. Yeah, Robert McBurney. Yes, I will be here. I will have the microphone muted. Again, I want to thank all the subscribers to this channel. Thank you so much for your support. And the people who rewatch most of my content. Thank you for your support. If you're not a subscriber to this channel and you like this kind of content, please do me a big favor and subscribe to this channel and help get this channel past 500 before the end of this year. And I know we can do it. We have a good community. And by all means, everybody, please share this stream and any stream out there on the internet. Let people know that this channel is here and what we are doing on this channel. I really appreciate it. So let's get started with Judge McBurney. Yes, I will be here, but I will have my mic muted. So let's make it bigger.
All right. Good morning again. We're all fired up with equipment and ready to go. We have 3 calendars this morning, although currently Mr. Lonzie Johnson wasn't brought over. So we'll see what's happening on that. What's the update?
They apologize.
As they should. They put him on a helicopter.
I was gonna ask who wants him right now? Do you want him on Zoom or do you want him Thursday?
Could we get, is it possible to get Lindsay here today?
I think so. I'm not sure exactly when.
Okay.
It might be that we, if you want to let family know that we say, let's effectively add them to the final plea calendar, because that would give folks till 1 to get them here.
Okay, that would work, because I do have a pad representative. Right.
Okay. Yeah, if we can let Pat know to be here at 1,
Okay.
that would be great.
Okay. I'll do that.
Thank you, Ms. Nelson.
Welcome.
All right, so we have 2 calendars this morning, a plea and arraignment and an inquiry calendar. We'll start with the plea and arraignment. Positions 1 and 2 are Mr. Robinson, Sheree Robinson, in custody. Thank you. Is it the lower? So this would be Ms. Rios, your cases?
Yes, Your Honor, and I did file an entry for a waiver for both. I just do need to talk to him.
Okay.
But I think, I don't believe he's being held in on these cases. It's another case holding him a PI case.
Okay. Well, he's here, so you can chat with him. I want to say hello. After you've had a chance to talk to him, it could just be bringing him to the door, but just to let him know what's going on. But you've done a waiver already, so we'll just get a scheduling order in?
Yes, Your Honor.
Okay. And any reason we shouldn't move both cases together?
No, in fact, I would like the PI case, so if we can try to get that indicted too.
That's a Ms. Smith production, so you have to talk with her about that. But that'd be great. All right, Kerwin McCallman. Was here twice to.
Judge, he should be on Zoom.
Okay.
Super slow.
I am here.
There you are, Mr. McCallman. This is the 3rd time we're getting together for you to hire an attorney. Tell me where we are in that process.
Yes, sir. As before, I was able to attain some of the funds, but unfortunately, things didn't work out as I had planned, and I wasn't able to get all the resources I needed in order to attain legal representation. I am still working on it, but unfortunately, I wasn't able to do it as I had promised to get it at this point in time. Things didn't fall to the way I expected it to.
Okay. Do you know Ms. Rios? Is this someone you spoke with and he did not qualify, or he's someone who expressed an interest of trying to retain an attorney even though he qualified?
I don't believe he ever qualified. I don't think the public defender was ever on his case.
Okay. I'm looking it up. We'll see. Mr. McCallman, we've sort of reached the point where you either need to be representing yourself until you hire an attorney, if you are ever able to do that, or I need to get appointed counsel to represent you. The allegations are old. They're from October of 23. We're coming up on 2.5 years past that. And I've given you now 3 months to line up an attorney, and that didn't happen. So let me see. Yes.
I have been diligently trying to do so. It's not without any effort at all. I have been trying to do so. Things is just not falling into place for me.
Okay, I hear you. I'm not suggesting you haven't been working hard at it, and I appreciate that you were doing that. I know you had Mr. Smith. Scott Smith was your attorney before this case was indicted. Maybe he helped with bond or something like that. But he was allowed to withdraw. Is that who you're talking with to get back on the case, or are you working with someone else?
I reached out to Mr. Smith, and I reached out to someone else as well, just to see, who would try to work with me and work with my situation as well. So there's been two individuals.
Okay. And let me check one thing. All right, so you are not based here. You're based in Ohio, which makes it complicated to try to line this up. Are you employed right now?
Yes, sir. I'm at work as we speak. I just took a quick break to to be here.
Tell me what you do.
I'm a security account manager.
What does that mean you do?
I just manage the security staff of about 30 people or so.
Meaning like a security a company that provides security guards, but you're on the management
Yes.
side of that rather than walking around with a flashlight.
Yes, sir.
Okay. How long have you worked there?
Since 2024, May of 2024.
Okay. Who do you support besides yourself?
My wife and daughter.
Okay. Does your wife work?
Yes, sir.
What does she do?
I believe she's in one of the financial officers for her company, or she
Okay.
oversees the payroll.
Okay. Well, I'm at a loss, Mr. McCollum. You've got a dual income household, and you've had 3 months to do this. Why is another month going to make any difference?
So, see, the issue I'm having when this situation initially came up, unaware to me, and I was sort of apprehended here in Ohio, and I had to make bail here. I, of my own accord, traveled to Atlanta because I wasn't sure what these charges were about. And so I turned myself in Atlanta, Georgia. I was picked up there and I had to make bail there again. So I had like two different loans I had to take out in order to make bail, and that's kind of what's tying me up now because those two instances.
Okay.
But I just recently try to see if I can get a equity loan, maybe to see if that will help. But I've been, doing whatever I can on my end, of course.
Okay. So I just looked at your bond. It's a big number, but it was through a bonding company, I assume.
Yes, sir. I had to make a down payment, of course, in order for them to even move forward with it here in Columbus. And then I had the one in Atlanta as well.
Oh, yeah, you had a big bond. Your bond in Ohio was huge.
Yes, sir.
Has that not, I mean, you shouldn't have to be, that bond should be done now.
I'm still paying on that as well.
Okay. All right. So what do you suggest?
My suggestion, like I said, I just recently, well, I'm in the process here to say, I don't want to be any untruth, filling in my application for a equity loan, and I'm hoping that goes through. And if that's the case, then I should be good to go.
And what's the timeline for something like that?
I'm not quite sure. I haven't spoken to a realtor, and I think it takes about, I don't know, maybe 2 or 3 weeks.
I want to set a deadline for you either to be here in person, which I know is inconvenient, which is the point, or to have an attorney have filed an entry of appearance in the case. So we know Mr. McCallman has a lawyer, but I don't want that deadline to be too soon so that you just come all the way down here and say, I haven't even finished applying for the home equity loan. But tell me what you think is a reasonable deadline so that we can say either you are here in person and I'm going to introduce you to the public defender, or a lawyer has filed an entry of appearance and then you can just appear via Zoom like you are doing right now.
Correct. Perhaps sometime in May.
Okay. We have a calendar on May 5. May 5. I'm going to have you added to that calendar on May 5. You'll get notice. It's going to go to your address. You seem to have a stable address. Sounds like it because you're going to take out a home equity loan. You need to be here in person on May 5. unless you have retained a lawyer and that lawyer has filed an entry of appearance. And the lawyer will know what that means. It's just getting something in the docket saying, hey, I'm Mr. McCallman's lawyer. This is who the prosecutor can talk to, and we can finally move this case forward.
Yes, sir.
You feel like you understand what's happening?
Yes, sir. Very much so.
Okay, so May 5, we'll see you again. Oh, that's funny. Ms. Nelson picked the same day. I didn't even see that, but she wanted you to be here on May 5, and that's really what would have driven it. Luckily for me, I picked the right date. So May 5, or a lawyer has filed an entry, and then you'll still have court that date, but you can appear just as you are now, and your lawyer can be here in person, waiving arraignment or doing whatever the lawyer decides is in your best interest, okay?
Yes, sir. Thank you very much.
Any questions?
No, sir.
All right, good luck with everything.
Thank you. Thank you. Bye-bye.
Bye-bye. Rashad Fagan. Ms. Rios, Mr. Fagan has, oh, that's right. This is, I think Ms. Cabrera has it. Is Ms. Cabrera planning on being here, Ms. Nelson?
Yes, she's gonna join via Zoom. I'll reach out to her.
Okay. Mr. Fagan has a lot of moving pieces. You're lucky he's a conflict. Okay. Ivan Dodds. I think he's not here yet. Okay, but he is scheduled to be here? Okay. He's on his way. Great. Okay. We'll handle that. Is Ms. Gordon handling that? Ms. Gordon? Okay, just today, or Ms. Gordon isn't doing, she pulled back from one thing. I can't remember if it was competency docket or juveniles.
So that's before 40.
Okay, so
Today.
got it. So it will be her case. You'll handle it when Mr. Dodds gets here. Great, thank you. Antavius Hill. Hello, Mr. Hill. Good morning. Mr. Hill, do you have a lawyer? Do you need to talk with the public defender? It is possible. Well, I'm going to have one of the public defenders talk with you, make sure you qualify, and then they'll take it from there, okay? All right, so Ms. Wood, that would be you?
Yes.
All right, so Ms. Wood will talk with you once we finish calling this calendar. Lexi Armour. Hello, Ms. Armour.
Judge, I think she will be mine based on the entry. I do need to connect with her and get a good number.
Okay. So Ms. Armour, just like with Mr. Hill, I'm gonna have you sit tight. Ms. Wood will talk with you, make sure everything fits, and then she's gonna make an announcement on your behalf after you two have spoken. Jaden Ashley. Hello, Mr. Ashley. I'm all right. How about you? All right. Do you have a lawyer or do you need to talk with a public defender? All right, Ms. Wood, you've got a busy dance card. Artie Leidecker.
Position 8 and 9, I was in.
I see that, yeah.
Uh-oh, did I?
Figure out which one.
I guess for the 10th. Position 8 and 9 are currently.
Oh, look at that. So Ms. Armour and Mr. Ashley, I didn't realize, I missed it. You all are co-defendants? And so Ms. Wood can only represent one of you. My guess is, don't quote me on this, my guess is it's going to be Ms. Armour because I think the public defender was plugged in earlier with Ms. Armour. That does not mean, Mr. Ashley, you got to go find your own lawyer. We will still appoint someone. I'm going to have Ms. Wood talk with you very briefly just to understand your financial situation. She's not going to talk to you about the facts of the case or if you know Ms. Armour or anything like that. But if you qualify financially, she'll let me know, and then we'll get a lawyer appointed to represent you. And it may well be someone who's going to hop on Zoom later this morning, but she won't know for sure. It has to get cleared by the people who end up ultimately paying for it. So today we probably won't be able to figure out if you're waiving arraignment or not. We need to bring you back one more time to get things rolling once that appointment's made, okay? All right. Thanks, Ms. Simpson. So, second chance, Artie Leidecker. All right. Bench warrant, Ms. Smith?
Yes, Your Honor.
And there's Rashad Fagan again. You want, pardon? Resolved. Oh, okay. Okay. Then we have some revocations. Raheem Conley. Ms. Wood, will you be handling that?
I'm not sure, Judge, this is the gentleman who, the last time he was on the calendar, said that he wanted the private attorney.
Yeah, he said he was getting a private attorney because he has 2 unindicted cases and he wanted to have them resolved.
Okay, so we'll need to ask Mr. Conley.
Yes.
All right. We don't know if it's Mr. Olaloye, just he was saying I'm hiring someone.
For Solar, or it wasn't Mr.
Yeah.
Okay, well, we'll bring him out in a little bit and ask him. Frederick Avery? Ms. Rios, are you handling that?
Yes, I will, and I'm ready for the creation application.
Okay. Mr. Irvin, I didn't mean to speak over you. Are you handling that case? Oh, he's got 2. Mr. Irvin, you have a bad connection. We can't hear you.
Can you hear me now?
Yes, sir.
Good morning, Your Honor. I'm here for Mr. Dilbert. The state and I have been discussing a matter in terms of negotiations. We've gone back and forth. We're still in the process of it. I think the state wishes to go on the record with respect to what they've offered, and I'll wait for the state to do so. But Mr. Peoples is here. He's present. Bradley Dilbert, I'm sorry, is present on the Zoom call.
Okay, I saw him on a Zoom call. I don't see him on any calendar, so I'm going to look his case up in a minute, but it's not on one of the calendars this morning. Okay, he's on, we may be able to tackle it. He is on, I see, he's position 7 on this afternoon's calendar.
He didn't say it was 1 o'clock.
Yeah, 1 o'clock, but you're here and Ms. Smith is here and Mr. Peoples is here. So we'll knock that out this morning. Since everyone is together, you're just gonna have to wait a sec because I'm still calling the morning calendar.
That's fine, Judge. Thank you.
Sure. So Ms. Rios, Mr. Avery has 2 cases. You will be managing both those?
Yes, sir.
All right. And is that a revocation we can do today or you need to talk with Ms. Smith?
I mean, we can handle that.
Okay, well, let me know. We also have inquiry calendar. Position 1 is Sental Burse. And he should be in, Deputy Gordon got pulled away. Hold that thought. Burse. He's here, okay. I guess that's Ms. Cabrera. He got picked up on a bench warrant. Gavarius Hill?
My God, she's in custody.
Okay. Okay, so he's en route. All right. Alexis Scott. I think I saw Miss Scott. Hey, Miss Scott, your lawyer, Mr. Hines, have you been in touch with him? Great, we'll wait till he gets here, okay? And then Rashad Fagan again. All right, that's it for this morning's calendar. Is there anyone here who thought they had a case, didn't hear their name called? All right, Ms. Smith, if we go to Bradley Peoples and Mr. Irvin and you, are you able to talk about that case right now? All right. Mr. Abadi, good morning. Are you here as a supervisor or did you think you had a case?
Yes, both.
Okay.
I'm here on Mr. Fagan's case.
Oh, okay. All right. Ms. Cabrera is handling those. So when she plugs in, we can knock that out.
Thank you.
What is happening with Ms. Jones-Connor's cases? No one showed up initially in front of Emerson for her case, nor did anyone ever say, I had heard she was leaving, but no one said, hey, don't call this case out or it's going to be Fred Smith handling it. What's the management plan for her? Okay.
Which case? Oh, the Dunaway's case.
Yes, exactly. And Emerson and Judge Emerson said, I'll continue it. But at first he said there's no one here from the state for that case. Eventually, I don't know if Ms. Charles talked about it or someone showed up, but yeah, it was C. Jones. We had two Joneses, but C. Jones. And he continued it. I just want to make sure she don't have any other cases on this calendar. So the next one is not till April. I guess people will have backfilled by then.
Yes.
Okay, then we're good.
She had actually was supposed to leave on Tuesday last week, but then Dunaway called her into the trial. She decided she was gonna see it through.
Okay.
That was the reason.
That's why she was still around, because her I have left message didn't start hitting till yesterday. Okay, interesting. One last pound of flesh. All right. Hello, Ms. Williams.
Good morning, Judge. How are you?
I'm well. Good to see you. So Mr. McCallman, I think, is your one case from this morning.
Yes, Judge.
We had a very long talk. He was live from Ohio.
Okay.
And he has been given until May 5. He's going to be on a calendar on May 5, and he either is showing up in person all the way from Ohio to meet with the public defenders, or someone will have filed an entry of appearance on his behalf before then, and then he can zoom in from Ohio, and we'll see if that person's waiving arraignment for him. But we heard a lot about his financial situation and the steps he's taking, and we agreed, all right, May 5, you got to come all the way back here if you don't have a lawyer, as a way to prod him to do that.
Okay, understood.
And that's it. So still no waiver of arraignment. We're still waiting, so he'll be on that. It'll be a clean arraignment calendar, hopefully with a lawyer attached to him.
All right, sounds good. Thank you, Judge.
You bet. Ms. Smith, let's talk about Mr. Peoples, if we can. So there's Mr. Peoples, and there is his lawyer, and there we go. All right. Ms. Rivers, good morning.
Good morning.
Is your daughter's tire all better?
Yes, she has a brand new tire. She's on her way.
Excellent. Well, I'm glad you were able to assist. We're going to handle position 7 from this afternoon's final plea calendar. And we'll get on the record for that. It's 25 SC 005-424, State versus Bradley Peoples. Mr. Peoples is represented by Mr. Irvin. Both of them are on Zoom. Ms. Smith is handling the case for the state. Mr. Irvin, I'm going to start with you. Have you received what you believe is all the discovery in the case?
Yes, Sean, we did receive it, and unfortunately, on my side, we received a document from our local public defender's office that corrupted our system. So I did ask Ms. Smith if she would kindly resend it again so I could download it again, because that particular server that we have, we had to discard it completely. So, but I did have it, yes, sir.
Okay. So you don't have concerns about, I mean, you have a concern that your server got corrupted, but not that the state's discovery was incomplete.
That is correct.
Okay. Ms. Smith, what is the offer for Mr. Peoples if he wanted to resolve his case today?
The offer in this case is 20 years to serve 10 with the balance prorated.
Ooh, okay. Mr. Peoples, do you understand what the state is offering right now? It would be 10 years in custody followed by 10 years on probation. So total 20-year sentence, 10 in custody, 10 on probation. Do you understand that?
Yes, Your Honor.
Okay. And is that something you and Mr. Irvin have discussed?
No, Your Honor.
Okay. Well, Mr. Irvin, you had mentioned there was something that you wanted to share, or that you said the state was going to share. Was it simply that offer, or what was it?
Well, the state extended the offer, but we're still in discussions in terms of going back and forth with it. That was the first offer, and I've made a counter offer, so we're in the process of discussing it. That's basically what I want to go on the record with it. I'm sure the state wanted to go on the record as well with their offer. We are rejecting their offer, but we are in the process, like I said, of going back and forth. Hopefully, we can reach some type of happy ground with this.
Got it. I hope there is a middle ground. Where we are right now, Mr. Peoples, hey, do you live down in Savannah?
Yes, Your Honor.
Okay, good. Mr. Irvin has explained on your behalf that you're rejecting that offer, which is fine. That's your decision. The only thing that changes after today, you can still enter a plea between now and your trial. You're going to be on a trial calendar at the end of April, so a month and a couple weeks. And you'll need to be here for that trial calendar. It's an in-person thing, so you'll need to travel from Savannah. Between now and then, you guys may work the case out and come on in for a plea. After today, the one thing that changes is that if you do enter a plea, you are not able to withdraw it if you don't like the sentence I give you. And let me give you an example. Let's fast forward to the beginning of April. Mr. Irvin has negotiated something with the state, and you come in and Mr. Irvin recommends a sentence of 5 years to serve 2 years. And I'm making this up, but let's just say that's what it is, 5 years to serve 2 years. And I hear more about the case and how a victim was injured in this case. And maybe I learn about your criminal history, and you may have no criminal history, but pretend you do. And I listen to all that and I say, you know what, Mr. Peoples, actually, I think the right sentence is 4 years to serve, not 2 years to serve. That would be your sentence, and you could not withdraw your plea. Today you could, if you decided to enter a plea and Mr. Irvin recommended 2 years and the state recommended 10, and I went with the state's recommendation. That's a whole lot more than what Mr. Irvin recommended, and you could say, no, thank you, and back out. After today, if you enter a plea, you're stuck with whatever sentence I give you. You understand that?
Yes, Your Honor.
Okay. Just like if you go to trial. If you go to trial and a jury finds you guilty, you don't get to say no thanks to the sentence. Your sentence is whatever you get. But of course, Mr. Irvin will be advocating on your behalf throughout it all, and he may argue for something different than what the state recommends. Between now and the end of April, make sure you stay in touch with Mr. Irvin. He is going to be working closely with the prosecutor to see if he can get you a different offer from the state. And if it reaches a point where you want to enter a plea, either because it's negotiated, both sides agree, or non-negotiated, you're not too far apart and you want to go forward with it, then we'll get you in court and we'll handle that plea. Otherwise, I'm going to see you on April 23rd. That is the trial calendar call. And like I said, you'll need to be here in person for that, just as will Mr. Irvin. Mr. Irvin, any questions about anything in the case?
No questions, Your Honor.
Ms. Smith, will it be easy enough for your team to resubmit discovery to Mr. Irvin?
Yes, Your Honor.
Great. Thank you for doing that. Mr. Peoples, any questions before we sign you off?
Not particular case. It was really a case of self-defense.
Okay, don't talk to me about the facts of your case. Mr. Irvin's not going to want you to be talking about that with the prosecutor listening. I just wondered if you had any questions about process, about what's going on.
I was going to ask, is that what we're going to discuss on the next court date?
So you and Mr. Irvin are going to discuss all sorts of things like, hey, if we go to trial, what's our defense going to be? And what are the risks of going to trial? And does it make more sense to try to enter a plea? When I see you on the 23rd of April, I'm simply going to be asking your lawyer, have you resolved the case? And if not, are you ready to go to trial? And hopefully the answer is yes, because this has been rattling around for a while. You got arrested back in June of 24, so we're coming up on 2 years. And it's time to get closure for you and for the alleged victim in the case. And that's my goal with that April trial calendar. Okay? All right, Ms. Smith, anything else from the state?
Nothing further, thank you.
All right. Well, Mr. Irvin, thank you for dialing in. Mr. Peoples, you do not need to dial back in at 1 this afternoon. We've taken care of this. I will move your case to the trial calendar.
Thank you, Judge. May I be excused?
Yes, sir.
Thank you, Judge.
All right. So we got through calling this morning's calendar. We're waiting on Ms. Cabrera. And I think, Ms. Wood, you needed to speak with some people. So why don't you do that? I'm going to talk with Mr. Hines and Ms. Smith while you do that. So, Mr. Hines, good morning.
Good morning, Your Honor. Please forgive me for being a little sorry.
That's all right. Ms. Scott said you were on your way. And as you could see, we've been handling other things. BHTC did not work out for Ms. Scott. She is low risk, and that's not who BHTC works with. So we need to know what else is next, or what is next with the case. And that's why I had Ms. Nelson bring everyone in.
Yes, Your Honor. I received the state's new offer, which in candor to the court is a reiterated offer from before BHTC was on the table. I was supposed to be in trial yesterday. The case was dismissed, but Thursday, Friday, and this weekend I was heavily in trial prep. So I haven't responded to this now. So if Your Honor would be inclined, I would ask for a, new final plea date so that we can have it worked out by then and maybe come to a resolution that we're both happy with.
So we've already had final plea and we were on a trial calendar. We took it off the trial calendar in the hopes that BHTC would work out, but it didn't. So the next stop would be the April calendar you just heard me mention with Mr. Peoples. So it would be to put Ms. Scott on the April 23rd trial calendar, not because it's necessarily going to be a trial, but at least we're backstopping it so that if for whatever reason you all haven't reached either a negotiated resolution or one where you're close enough together that it's a non-negotiated plea, then we can have a trial. I don't know that that's what anyone wants or that anyone needs, but I need to have the case moving in that direction rather than resetting it back to a final plea. We did that. We got to a trial calendar, and BHTC seemed to make a lot of sense, but for reasons I now understand, that wasn't the right fit.
Well, and Your Honor, it's caused a situation for the court, but I'm definitely, not displeased that Ms. Scott was found to be low risk. That's just a testament to the work she's done since these allegations.
Oh, no, it's a great finding. If it was, we don't have the ability to treat her, in other words, she's too high risk, high needs, that would mean we're moving in a very, very different direction. So it was disappointing in that you all maybe had arrived at a solution, but I didn't view that as a bad development. It's a good acknowledgement.
We're just still working on it. So would we be able to present it? I think I heard you say we would be able to present a negotiated plea at that trial calendar.
So I'll have to check with Ms. Nelson. I don't remember if, hold on 1 minute. I don't remember if Ms. Scott rejected an offer and so the final plea has already happened, or if we preserve the final plea rights. But that'll be on the calendars that Ms. Nelson has. So if I preserved her final plea rights, they will remain preserved. If I didn't, then they won't. I don't know much about this case, but the way you and Ms. Smith have been working together, it strikes me as a case where people aren't going to be all that far apart. And so the final plea rights are less essential than maybe the preceding case where the state's offering 10 to serve. And my guess is Mr. Irvin's going to say some lesser number. And so the passage of those final plea rights is pretty significant. I don't know that that's this case, but I'll abide by whatever I said before. I just don't remember that answer. Ms. Nelson will have memorialized that on the calendars.
Yes, Your Honor. And just off the top of my head, is the 23rd a Thursday?
Probably. We often call calendars then. That won't be when trial starts. That'll be, it is a Thursday. that'll be the call of the calendar. So everyone shows up, and that's sort of your last chance to work it out. Because if you don't, then I know these are the 3 cases left. And we agree that next Monday, I'll see you and you and you, and we'll see who goes to trial.
Yes, Your Honor. I'm set to be in trial in the cab for a specially set murder from the 13th through the next week, which is, I think, ends on the 24th.
Mm-hmm.
I don't know, I mean, except for jury deliberation, if it'll go that long. So I can definitely be in touch with Ms. Nelson with the appropriate conflict letter or whatever the case may be.
Well, 2 things about that. Ms. Scott will still need to show up. There's no reason if you and Ms. Smith sort something out, we can't do that before you start your specially set to cab murder trial. That's another reason to jump on this one. And you're here, and Ms. Smith is here, and Ms. Scott is here. So I'd hope before you go, you guys talk some more about what alternative might be. And it sounds like Ms. Smith has said, here's the state's suggestion. And if you have some counter offer or mitigating information, it's a great chance to have a face-to-face since everyone's here.
Yes, Your Honor.
Okay. Ms. Smith, is there anything you want to add about Ms. Scott's case?
No, Your Honor.
You're ready to go whichever way it goes?
Yes, Your Honor.
Okay. Ms. Scott, do you have any questions?
No, Your Honor, I wasn't really pleased with not being able to get into those cases, but I believe whatever is most fair option.
Okay. Well, I'm with you. I was excited by that as a potential solution, but it's not a knock on you. In fact, what they concluded was that you've achieved a certain level of stability in your life that we have limited resources with the accountability courts. And so we try to apply them to folks who most need it. The conclusion was not that you wouldn't benefit from more support, but you were in a much more stable situation than other people who were applying. So like Mr. Hines said, it's sort of good, bad news to get. All right, well, I'm going to ask you to stick around while Mr. Hines has a chance to talk with Ms. Smith. And then if anything changes, you guys can let me know. Otherwise, you should feel free to head out after you've engaged with Ms. Smith.
Thank you, Your Honor.
All right, thank you. All right, I'm going to come back, Ms. Wood, when you're ready with a couple of yours, unless there's something else we can do right now.
Judge, I'm on.
Oh, Ms. Cabrera's on, but yes, Ms. Wood, you were going to say?
Ms. Armour, we connected, she had a good address on file, she's here today, I've gotten the number, I just gave her mine, and I'm just gonna file a waiver today.
Okay, Ms. Armour, let me look up your case. So you will do a waiver, you said?
Yes, sir.
Thank you.
There you go.
So Ms. Armour, you live in Chattanooga? Yeesh, okay. Going forward, make sure you check with Ms. Wood because it may be for other court appearances. It's okay for you to appear via Zoom, so you don't have to come all the way down here. And she'll let you know. I don't mind if we're just having a basic conversation. If it's something real substantive and you might have witnesses testifying, I want you to be here. But otherwise, I don't mean for you to come all the way down here if it's going to be not a major event. Your bond order hopefully says it's okay that you're in Chattanooga. You are not supposed to have any contact with Mr. Ashley. Have you been maintaining that? No contact. Okay, good. And you're not supposed to have violent contact with the police. Hopefully you're doing that. And that's really it. Are you working or are you a student? Both. Where do you go to school? Pardon me? Okay. And what do you do for work? Okay. Well, you sound like a busy person. Stay in touch with Ms. Wood. She'll let you know what's coming next with your case. She's going to get the discovery in your case, so police reports, maybe body cam footage, things like that. And then she will let you know what's happening next, okay? All right, if you don't have any other questions, you're good to go. You're welcome. Mr. Ashley, Ms. Cabrera is on the call. She may end up being your lawyer. I'm going to tell her about your case in a minute, but Ms. Wood has determined she's representing Ms. Armour, so we'll be getting a different lawyer to represent you. We can't resolve that today. All right? Ms. Cabrera, good morning.
Good morning, Judge. How are you?
I'm well. Good to see you. Where are you calling from today?
I'm in Cobb County.
In Cobb.
Just outside the courtroom.
Great. You have one for sure client and maybe a new client, but we'll work through Mr. Luemba or whatever we need to do. The for sure client is Mr. Fagan, who appears on this calendar about 9 different times.
Yeah, and that's what I wanted to, and I'll go through, I think Ms. Nelson has emailed us a calendar. I have to confirm that all of the cases are actually mine, and that I'm not sure of.
Okay. Well, I'll make sure if you work with Ms. Nelson that you get all of the case numbers. He has 2 that are consecutively numbered that you're listed as his attorney and you filed an entry and a waiver. So I'll mark that down. Waive for the case ending in 125.
Okay.
And you did the same in 126, so those are covered. And that's Cabrera.
I should have one that ends in 178.
Yeah, I'm gonna get there. He was on for a revocation, but that's already happened. So that's good. And then he had, 178. And that's it. Those are the 3, plus there was that revocation. But like I said, the revocation has happened. So we don't need to worry about that. So I think you've got all 3. Did you do the one ending in 178 is old?
It is.
Had it already been arraigned or
I don't remember, but I imagine so. I'm just looking at, it must have been arraigned because the one on 178, I got a scheduling order. For.
Oh, right. And then he disappeared on us. There was a bench warrant in May of last year for final plea.
Right. And that scheduling order was done back in February of 2025. So he had an arraignment on that one for sure. Okay.
So what we'll do, is Mr. Fagan here? Yes. I'm going to bring him out in just a minute, but just so we walk through this, you did the waiver back in January of last year. You're right. There was a scheduling order. My suggestion is, if you're all right with it, is that we do a scheduling order for the 2 new cases. Looking at the charges, they don't look real complicated, so we could have it be a kind of accelerated scheduling order, the main part to be getting you the discovery, but we tap the brakes on what I'm calling the gang case. That's the older one, so that these other 2 catch up to it.
Okay.
Does that work for you?
Yes, it does. And then hopefully we can get some sort of I'm pretty sure whatever happens with the gang case is going to control what happens to the other 2 cases.
Okay. Ms. Smith, are you handling all 3? I know Mr. Abadi is here and he said he was prepared to talk about the gang case. It's got your name on the calendar.
For position 4 on the plea arraignment, that is my case. Position 5, that'll be ADA Willingham's case.
Oh.
And then for the one that's on the inquiry calendar, position 4, that'll be Mr. Bobby's case.
Why have 1 prosecutor when you can have 3? Okay. All right. It sounds like to line up a global resolution, Ms. Cabrera, you'll want to work with Mr. Abadi. And to your point, the gang case, the older one, which is Mr. Abadi's, that would be the one that kind of dictates what happens with the other 2. So I'm going to leave it to the state to figure out who's going to send you discovery in the 125 and 126, but you'll get that. And then please work with Mr. Abadi as you think about an overall resolution.
Okay.
Do you know, are there any unindicted cases for Mr. Fagan, or is he basically being held on a bench warrant in the gang case?
I think he's being held just on the bench warrant for the gang case. I can check.
Okay. Can we bring Mr. Fagan out to the podium, please? Have you all met before?
Once upon a time, I think.
Okay.
But
We'll see if
it
you
was
recognize.
like, yeah.
Yeah.
It's over a year ago.
Yeah, he's got no unindicted cases, Your Honor.
Okay, great.
So it's just the 3 cases.
Yes, ma'am.
Judge, is there also a Centol burst on this calendar too?
There
I got a
is.
notice in the mail.
We'll get to him in just a sec.
Yeah.
Good morning, Mr. Fagan. I'm all right. You come right up to the podium there. Hey, I'm Judge McBurney. I've got 3 cases with you. And I was just talking with Ms. Cabrera. You can see her on the screen. That's your lawyer. She worked with you way back when on your oldest of the 3 cases where you're charged with a gang offense. More recently, you've been indicted for things that happened around Christmas time of just this past year. And so you've got 2 cases. Ms. Cabrera is going to be handling those for you as well. And I was just catching up with her as she was getting up to speed and figuring out which prosecutors can handle all those. So Ms. Cabrera is going to get discovery in the 2 new cases as well, and then connect with you to talk about what do we do? Do we try to resolve all 3? We go to trial on one? Is there a motion to suppress in one? But she'll talk with you about that and then let me know what do we do next to move your cases along. All right?
All right. Can I say something?
As long as you're not talking about the facts of your case, you certainly can say something.
I took a year for probation violation. Do you think they're going to send me down to prison and not finish this? Or am I going to finish this first?
So, great question. 2 things. One, I know Ms. Cabrera is going to try to see you soon in case you do go to the Department of Corrections. But even if you do, we don't forget about you and we don't stop working on these cases. We will patch you in via Zoom if it's a simple conversation. And if it's more involved, I just do a production order and bring you back. So I don't know the answer to that. That's a sheriff and Department of Corrections conversation. A year revocation typically means that you go to the Department of Corrections, but it doesn't always mean that. But I appreciate you flagging that because that's a reason for Ms. Cabrera to come see you soon. You're a lot easier to see. Are you at Rice Street? At Rice Street than you are in Valdosta or wherever you may end up. But we will not lose sight of you. In fact, I just talked about entering a scheduling order that will move your 3 cases together and quickly. So if we need to bring you back, we will certainly do that. Or if we need to keep you here because we're about to work them out, I can do that as well. That's an important thing for you and Ms. Cabrera to discuss when she connects with you. All right?
I would like y'all to discuss, try to keep me here, 'cause I don't want to go down there and have to come back when I'm done. I got to go to 2 different counties after that.
Oh, you have other counties to hit. Where else do you have to go?
Clayton.
Okay, you would go there before you would go down to the Department of Corrections. So you'll stay close. It may be that you leave Fulton, but if you do, it would only be to go to Cobb or Clayton. And so you're just going to want to keep Ms. Cabrera posted so she knows which of those to hit. Okay? All right. Thank you.
Thank you, Judge.
You bet. Do you want to talk about Mr. Burse?
Yes. So Mr. Burse, is Mr. Burse present? Is he in custody? He was assigned.
He's here.
back in
He's here now.
2000.
Okay.
He's
here.
Okay. So he was assigned back in 2024, and then I don't know what happened after that. But he had, I had the case ended in 595, and then Ms. Nelson contacted us on, I think March 2nd to ask us about a new case that he has. And the new case that he has was given to me on March 8th.
Okay.
So I do have that one now.
Oh, 595, look at that. So the one that's on the calendar is a 24 SC case, and you've got that. He missed court also for a final plea, but a month earlier than Mr. Fagan. And in this newer case, the 595, it just got sent to us from Judge Farmer because of this older open case. So did you say you will have it assigned to you, or you don't know?
No, I do. I got so she emailed me March 2nd. We didn't have it
Okay.
March 2nd, but we did get it March 8th. So we
Got
do have
it.
it
So
now.
it's brand new to you and to me.
Right.
And you'll be handling that. Okay, great. Oh, and I see it's listed as being on for plea and arraignment today. Okay, well, maybe we can knock
And
out both.
I can submit a waiver too.
Okay,
The
great.
form that you use.
All right, well, we'll bring them out right now.
Okay. Do we know who the DA will be on both of his cases? Is that Ms. Smith?
Yes.
Yes,
I'll be in touch with you. I'll shoot you an email.
great. Mr. Burst, good morning.
Good afternoon.
I'm Judge McBurney. We probably met a long time ago. You have an older case and you got a brand new case. And we're here to talk more about the new case. I have on the screen Ms. Cabrera, who is your lawyer on both cases. She worked with you back in the day on the older case, which is marijuana, and you allegedly had a gun. The newer case charges you with aggravated assault, and it was indicted just a few weeks ago, got assigned to a different judge, but because you had the case with me, we try to have all cases with one judge, so you have one lawyer, one judge, one prosecutor, all that. So Ms. Cabrera is going to be handling both cases for you, and I'm going to ask her in a minute if she's waiving arraignment or not for you on this new case, and if she is, we'll get a scheduling order in, the prosecutor will get her discovery, and we can bring back to life your old case and have it move along with this new case. It makes a whole lot more sense to try to resolve everything together if they're resolvable. I don't mean to say they are. It may be that you should go to trial or the state should throw the charges out. But Ms. Cabrera will help you process all that, okay? All right, Ms. Cabrera, are you waiving arraignment in the 26 SC case?
Yeah, sure. We're waiving formal arraignment and entering a plea of not guilty.
All right, and you'll get that waiver form to Ms. Nelson. I'll get a scheduling order out. Ms. Smith will get you discovery in the new case. I assume you still got your case file in the old case that got put on hold when we couldn't track Mr. Burst down.
I'll check. I don't have a note on here that says when that discovery was received. Usually I write that down, but I'll check.
Okay, let me see if there's anything in the docket about, it got to final plea, so hopefully discovery was produced.
Yeah. Usually I just track when they send it to me because depending upon how they send it, there's a date that it expires. So I like to keep track of that usually.
Got it. Yep, that makes sense. And that was pre-Ms. Smith, so I can't vouch for the reliability of discovery going out or not, but.
I'll send her a message and find out.
Great. Okay. Yeah, check on that, and then we'll just have the two cases moved together. Mr. Burst, so today is really just this formality of letting you know I have both your cases now. More importantly, Ms. Cabrera has both your cases, so you've got a lawyer working on your behalf. She will get that discovery and then figure out a time to meet with you to talk about strategy, next steps, et cetera. And then I'll see you either because Ms. Cabrera has filed some motion or motions on your behalf, suppress this, do that, or because you all have sorted something out, and then we'll get you in here and see what that looks like. Okay? Any questions?
No, that's all.
All right. Ms. Smith, anything from the state?
No, no.
All right.
Thank you, Judge.
You're welcome. So I think that is it for your cases. Yeah, if that took care of Mr. Fagan, and then I don't think you have anything on the final plea calendar this afternoon. So you are released to Cobb.
All right. Thank you, Judge. If something happens, I'll be here. I got 3 courtrooms here.
Oh, one last thing. I met a friend of yours who rides bikes with you, which was hilarious because this dude, he's still built like a linebacker. I mean, he looks like he weighed 280 and like no bike would support you. And you don't look like a bike. You look like you would throw bikes rather than ride them.
Yep, he is like a freight train. He used to play for the Baltimore Ravens.
Yeah, right.
Really good friend of mine. He sent me a picture. He took a picture too. And
Yeah, we did a selfie. He said, I'm sending this to her. I'm like, all right, you do that.
Yeah.
That was funny.
That's my buddy.
All right. Well, take care.
Thank you, Judge.
Bye-bye.
Bye-bye.
Ms. Wood, anything else cooking from the plea and arraignment calendar?
Judge?
Yes.
I just never change of address to Ms. Nelson. I'll get a waiver file today.
All right, Mr. Hill. Hey, let me pull up your case. So the Morgan Road address is the old address? Okay, and whatever a good new address is you've given to Ms. Wood. Great, that'll go in the system because the official notice you get comes in the mail from the clerk of court to whatever address you share with us, which right now is that Morgan Road apartment. It'll change. The unofficial notice is the one that will be much more effective, and that'll come from Ms. Wood. She'll text you or someone on her team will call you when you need to be in court or when something's going on. So make sure if for whatever reason your phone number changes, you let Ms. Wood know that.
And then a couple months ago, we'll change the address just to make sure I got it.
Okay, I believe you, and I believe that it didn't work. And hopefully it works this time. More importantly, Ms. Wood is saying, look, I'm telling you his address has changed. So you're on the record of saying, hey, it needs to be something different. Only other thing I want to cover with you is bond. You are supposed to have no violent contact with a Ms. Bridges. Do you know who Ms. Bridges is? That would be Ms. Bridges right there. Well, don't have any violent contact with her. It's been okay so far? Okay. Pardon me? Okay. All right. That's the main condition of your bond is be nice to Ms. Bridges. Ms. Smith, is this going to be a Willingham case?
It is, Your Honor.
Okay.
Her only announcement for this case was that she would get offers out to Ms. Wood by the end of the week.
Okay. And hopefully discovery if it's not already out there. All right. Great. Then that's it. Ms. Wood, anything else? Mr. Hill, you are free to go. And Ms. Wood will let you know what's happening next. All right. Oh, Mr. Ashley, I blew it and I let Ms. Cabrera go, but I'm going to let you go now. 99 times out of 100, Ms. Cabrera is the conflict defender, and so she will likely be your lawyer. Every once in a while, they assign it to someone else, but she doesn't make that call anyway, so she would have just been able to say hi, but not guarantee that she's the lawyer. I want to confirm your contact information so that when we figure out who that lawyer is, we're able to provide it. So give me a second. You also are in Chattanooga. Okay. How close do you live to Ms. Armour? Okay, that's good. Chattanooga's big. Stay away from her because she's supposed to stay away from you. You're on Dayton Boulevard? Okay, so we've got a good address. I don't have a phone number, so if you would, Deputy Gordon's going to give you a note card. If you would write down the best phone number for you, your cell, mom's cell, whatever's most reliable, and put your name on the card, we'll make sure we get that to the lawyer. Since you are in Chattanooga, it's likely that the first contact is going to be that phone call and not showing up at your door because the lawyer is going to be based here. All right, and once you've written down that number, phone number with your name on the card and write it legibly, then you're good to go. And we're going to get you a new notice of when to be here with that lawyer. But you should check with Ms. Nelson, that's my litigation manager, about appearing virtually for arraignment. Virtual appearance is fine. I've laid eyes on you. I don't want to make you trek all the way down here for what would be, we waive arraignment for Mr. Ashley, and then that's it. So please do check with Ms. Nelson, and she'll likely say that you could just be on Zoom. Okay? Mr. Dodds is still not here yet?
He's here.
He's here. You need me to go away to bring him up? Okay, hold on. Let me just see what else is going on. Artie Lidecker, still a no-show. All right, bench warrant. Then we've got, can you bring Mr. Conley to the door? And then we'll take a quick break so you can get us Mr. Dodds. Mr. Conley.
Good morning.
How are you?
Fine.
Mr. Conley, when we last spoke, good morning to you. When we last spoke, you shared that you were planning on hiring a lawyer.
Yes, he already been retained, gave him 500. He's saying he want 1,500 more to take all 3 of my cases since the public defender don't want to be on my probation case anymore. So that being said, my money is tied up, so I can't just give him $1,500 right now, sir.
Okay. Well, let me look this case up. Are you saying that the lawyer already filed an appearance, or you're not sure?
Sure.
Okay, well, let's.
I gave him $500 payment.
Yep. Okay, yeah, and that's not Mr. Olaloye. That's not who we're talking about? You had a lawyer named Olaloye. That's who handled your case when you pled back in 23.
Oh, no, not him, it's Mr. Toller.
Okay, that's what you told me. All right, so when we last spoke, you said it was Mr. Toller. So he's taking some money, but he said if you want me to handle everything in a.
All 3 of my cases, he said he want 1,500.
Okay. 1,500 total or 1,500 more?
Yeah, 1,500 total.
Okay.
It's gonna be 2,000 total.
Got it. Okay. You said one thing that I'm confused about. You said the public defender doesn't want to handle my revocation.
She said she wanted to come off my case because I have a paid attorney for my gun charge.
Okay.
She was like, well, you might as well let Mr. Toller take all 3 of the cases. I don't feel like she represented me to the best of her knowledge anyway.
Okay. Well, it sounds like you don't want that situation anyway then, but I remember it a little differently.
Just offered me 2 years, she ain't.
Well, my guess is what happened, but I don't want you to talk about your private conversations with the lawyer, is that she said, this is what the state is looking at doing. And so if you want to do that, you can, or we could have the revocation hearing, like a mini trial, and see what happens there. So I don't have a gun. I have a theft by shoplifting case, is one of your unindicted cases. And the other one,
187.
yeah. Oh, okay. There was a gun. Okay. It was a, so you had something funky with your license plate. It must have been stopped. And then there was a gun in the car. Got it. Yes. So Mr. Toller's not listed as your lawyer in any of those. Tell me what you want to do. Do you want to figure out a way to untangle the money so you can get more to Toller? Or do you want me to, if you're not able to afford him, you can try to afford someone else, or I can appoint a lawyer to represent you. But you don't seem real enthusiastic about that.
Yeah, because the last attorney she didn't even say good morning. She just said, we offer 2 years. Do you want to accept it or not? And I was just like, no.
Okay. No is an okay answer. So tell me what you want to do. You want to try to sort things out with Toller? Because if you're not going to have the money, you shouldn't be stuck because you don't have the money. That's not how.
It ain't even that I don't have the money. because I have the money, my money gotta come in the check form. My taxes coming in the check form, so I'm waiting on it to come.
Okay. And is that your preference, is to wait till you get the money and get Toller on the case?
Yes, sir.
Okay. When, I don't want to have your, go ahead.
I'm saying, so today, could I deal with it today?
So let's ask Ms. Smith. Ms. Smith, has the state's recommendation in Mr. Conley's revocation changed?
No, Your Honor.
So it's still your recommendation and probation's is to revoke 2 years?
That's correct.
All right. So what could happen today, Mr. Conley, is that Ms. Wood, who you've not spoken favorably of, could advocate for a sentence of less than 2 years. She's not required to go along with the 2 years. She shared with you what the state's recommendation is and what probation's recommendation is. The discussion would simply be, is 2 years reasonable or should it be lower? It wouldn't be about the facts of the case. If you want to fight the charge, which you're entitled to, then the state actually has to prove up the situation with the license plate and the gun. They have to call a police officer, whatever it is, and we have a hearing. It's not with a jury, it's a bench trial, and the burden of proof is a lot lower for the state, but they still have the burden. They got to prove it. They don't just get to say, hey, he had a gun. An officer or officers or an eyewitness or whatever would need to come in and testify. We can do that as well. That we cannot do today. It was on the calendar today either because you guys had worked something out, or to figure out, are you bringing Toller in, or do you want to plug back in with Ms. Wood? So, yes, you could work it out today, but the state's going to still recommend 2 years. Ms. Wood will recommend what you and she think is reasonable. She may say time served, which for you looks like it might be a little less than 3 months. And she can say that. I'll listen to it. Doesn't mean I have to do it. I may agree with her. I may agree with the state. I may say, this isn't so serious. I think 6 months. But I don't know. I've heard nothing about it. So that we could do today, but you run the risk of it being 2 years because the state's recommending 2 years. If you don't like dice that look like that, then you should either engage with Ms. Wood and say, I want the hearing, they need to bring these officers in, or tap the brakes and say, I want to wait on Toller.
I didn't talk to Ms. Wood since
Okay.
I've been incarcerated. Only time I talked to her was when I came to court the last time, that was 2 months ago. So I don't know how she feel. I don't know.
Well, she didn't go to see you, so you know, because you told us I'm hiring Toller.
I'm
So,
talking about even before. I've been over there since December 21st. I
okay,
haven't seen this lady since
okay.
January 27th.
Got it. And she wouldn't come see you after that day because you told us all you're bringing Toller in. No other lawyer would come see you because you said, I'm hiring this other guy. And so lawyers are supposed to back off. So she did what she's supposed to do. But I'm not foisting anything on you. You need to decide.
So moving forward, so if I do move forward to that,
Yep.
2 years or
So if you move forward today, I would ask Ms. Wood to have a conversation with you so you could say, look, let me tell you all about it because it's a confidential conversation. You could say, you need to share with the judge this, that, and the other thing. She'll give you her thoughts about what a sentence is. She'll give you her thoughts about what I might do. She's in this courtroom all the time. And she could say, McBurney is a softie. McBurney can't stand guns. McBurney never has a license plate, so he'll be sympathetic to you, whatever the deal is. She'll give you her thoughts, and then she'll advocate for you for a sentence. But all we would be talking about today is which sentence is more reasonable. It wouldn't be, well, the state didn't prove it. But you have a right to have the state prove it. And if that's what you want to do, we don't need to wait on Toller. I'll set this down again a few weeks out. The state will need to bring a witness or witnesses to see if they can prove it up. Ms. Wood would represent you. She'd cross-examine the witness, and then she'd argue the state proved it or didn't prove it. That would happen likely sooner than you get Mr. Toller. But you've got these 2 other cases, and you may want to have one lawyer for all 3 of the situations. That's your prerogative.
I feel like it was no reason for her to just throw Mr. Toller onto my probation case. She didn't have anything to do with it. Well, Mr. Toller didn't have anything to do with my probation case. She's supposed to be my attorney for my probation case. I understand that, but I went to hire Mr. Toller for the gun case and the shoplifting case.
So we may have had a misunderstanding then, because what I understood you to be saying was that after we had our conversation, that you wanted to have Mr. Toller handle all three. And I may have misunderstood that, but
She said, Your Honor, can he just handle all three of the cases? Can he just take the probation case too?
Yep.
That was her.
okay. Well, regardless of who said it, what I took from it was that Mr. Toller was going to be your lawyer.
That's why he wanted more money.
Okay, got it. And so now we can unwind that. If you don't want to figure out how I'm going to get this more money for Toller and I want to sort out this revocation thing, you can. You'll be working with Ms. Wood if that's what you're going to do.
I want to see what she's talking about now.
Okay.
They're trying to come down.
All right. Then I'm going to have you pop back there now that you've cleared up that, hey, Toller is for these unindicted cases. I don't have the money for him for this revocation. Then in a minute, I'm going to take a break. Ms. Wood can talk with you about it, and then you guys can let me know what's going to happen. Okay? You bet. All right. Anything else before we take a break so that we can bring Mr. Dodds up? Ms. Smith, you good?
Yes.
Ms. Wood, you excited? Mr. Hines, probably because I've kept Ms. Smith busy, you haven't had a chance to talk with her?
Yes.
Great. Your opportunity is about to approach. And Ms. Rios, we're glad you're here. I know you got something on the calendar, so we'll get to that. All right, let me know when everyone's ready. Please.
A lot of talkative people today.
Oh, is that easier way? You guys, okay. Okay.
I'm leaving. I need to talk to Mr. Abadi.
Oh,
Can I see you for a sec?
yes. I'll send you the email about it, you can list.
Okay. I had a guy, he kept saying he was going to be on office.
Well, I think I'm sure that's.
Yeah, I gave up. That's why I always buy those. Really fortunately, I was like, well, we've got, so I got to arrive, my father, everything, that's what it's using, this was like, I was just said everything to be done. Well, no, I think Judge went to bring out. I already didn't have anything to bring, but I think it has. I know just he was on top. I know it's especially. Oh, yeah, he wanted to introduce himself. No, right.
And I think she had
Still not. Is she employed?
so she is. She's having a job.
Oh, you're good. You're not my seat.
In her vehicle.
So.
Okay, so Joe, yeah, we did.
I had heard diversions when I was in the court. Like, I was like, are you serious? This is really interesting.
What's this all over?
Okay, so you're just so. Yeah.
So this.
Like,
She was not feeling up there for us. So she did great because she really she just steps in. Like,
exactly. That's a dying breed.
right.
Because this new group, 3 cases.
Yeah.
And you quit overwhelming. I want me to do what it comes.
Right. It's always a shock.
You don't really, see, that's what you, the few of us that go, I talk about, but they have we're done 60 people.
Correct.
And you're supposed to be this, don't let this stuff out, or this, we go to get you. That version is the one. You might know like that. I want to do myself. What I can do is, 2 hours.
Because it's easy to get you deal with that.
They still care.
And then it's good. It's even easier. That's not bad. Which one?
There's a recent meeting where I had this provider all of the dispositions for treatment. She went and showed it. I called me. That's a. I did, so the first the office taking jobs out. It's like 2 years ago.
Right.
Like, also, I people who think 10 years. I can't even know. So I did a job. I sent my office. This is 3 years. It was 3 years. 3 kids have died.
Yeah, I think I've heard of it.
Right.
I heard they love that.
I'm gonna have James. One's getting changed.
So when we fought, well, I'm sure that some matter kids are just out there. We got the mandatory minimum. Hopefully, you know, to show you doesn't turn by it.
Oh, yeah, I get the letters.
And because it was our mandatory minimum.
I know she was
Make up that running breeze.
Oh, so we were part of, I don't think it was such a long time ago when we had the hearing, it was, I still have to, because that changed everything.
Yep.
It went all the way.
Yep.
Timothy, it's not Timothy.
I think it is.
Yeah, I still have it, I keep forgetting this, but she let it out early. And I want the whole thing to hear, but I have to go back to custody, but it was like 3 years later. By the time it was, Timothy Hudson.
Yeah. I knew it was something.
Yeah, Timothy Hudson. Yeah.
So.
Yeah.
I was gonna say about the seven.
I wasn't.
Yeah, I said
Once you treated it.
oh, but he has to do. That's, cause I can testify. That's not what I do. I was like, yeah, he was on the honor student. I didn't want to. Sometimes I look at this transfer.
Everybody else.
That was like,
We like mine was less us.
Yeah.
The very good part.
Yeah.
Yes. Well, I came over and I said,
Thank you.
all right. See ya. Happy whatever day to you. You all right? Now they're thinking of it. It's not even.
Sorry. Yeah, he did that. No, that's a juvenile case. It was a obstruction.
Yeah.
That's it.
Yeah, he's over
Casey, that's it. I'm at all of them. Yeah, I have to be at all of them.
He can do it if he can do it.
Yeah. I believe it's denied. It wouldn't have been, because usually.
Yeah, sure.
Because that was in front of judge.
Oh, yeah.
It's on, that's an option to do.
Yeah. So.
Yeah, it didn't have anything that was. So, yeah. Yeah, but I was, I forget the name. I chose the name. I don't have any recommendations. I made them. What do you want? Yeah, this. Typically, they have to do this kind of just set aside the facts. If you look at
I don't even think they're not gonna do anything with it, so. It's an unfortunate, because that's something over my head. So,
Oh, no, they would have been comfortable.
Yeah. This week is out, so we have to. And then just probably next week. BHTC is on the American. And very much more short. So. Secondly, there was coming back. My court, is pretty nice. I can speak. I want to go. I think she had a little bit more right. It's more than that. I go on that patient with us. We need to be something. Okay, I couldn't figure out the TLC. Yeah. I'm trying to figure that. I am.
So.
That thing.
Oh, why? It's in Chicago.
Well, for.
Mr. McDowell? So. I think we were. Now, do I think that the.
I have a regular on the file.
Afterwards,
Yeah.
And so we we're gonna try and faster.
Yeah.
It's being.
I think
And I
that.
think it's probation. You have no criminal history, so.
I totally understand. I think the. Get it out your heart. It's like 3 times. It's because I don't have things. I
really want.
I got. Because she worked. But when I walked in there.
The brain got shot in one day.
And so I. No, I just. So I said, I'm not hurt one case. And I was like,
But that's the offer I had.
what
It's gonna be
is this?
probated off
And I'm giving some.
with first to fifth.
Like 5
And
times.
with- You like the third or fourth person on.
Yeah. I had never known talk about Yeah, we do, but when I'm seeing things out.
I mean, I really never had.
Appreciate it. It's very nice.
No, I usually write notes. I'll frequently confirm you out. I'm not sure.
Because you know, so used to that, going on, it's like, now I can't all day. I mean, that's what I don't. And then the other one. I won't. I'm gonna go. Nobody got
You're still gonna be.
How was your weekend?
So one person saying, I didn't know
There's literally no no.
Oh, fuck it.
That's the
That's the first thing. I said, well, that's so that's not wrong. I didn't look at it. It's like, oh, she's like,
I think it's actually.
and that's why I go. I haven't responded. That's the first thing I
I need to file.
I think okay. I don't want to make the. I just look at you said that's how well that yeah, I got a shot. It can't be or cautious.
Before me, we had.
Gilligan was when we talked to.
Yeah.
And then.
Good. Those are kids. I think. I think
she's in. I think she's in.
I remember saying maybe, but I just.
Oh, yeah.
This is
Cases, she's filed a waiver of arraignment for you, and we're moving them forward. And I just wanted you to know why you were brought over today. You had cases in non-complex. One got transferred and the other joined it. And we're going to figure out what we're going to do. She'll get discovery from the prosecutor or from her predecessor on the case if discovery was already provided when it was in non-complex. And I'll make sure that things move along at a healthy pace, okay?
You by any chance, Your Honor, you by any chance have any idea when I will be able for your next court period? Because see, it's a total of 9 months.
You've been in custody for 9 months?
Been previously. 5 months before I got bonded out on this case that we were in before, and then now
We've got 2 cases.
I got 2 cases, Your Honor.
Yep, there's a stolen property case and a shoplifting case.
Right, and I found out since when I was incarcerated from March 21st of last year.
Yep.
It was dismissed, and then I found out how this true bill thing go about.
Yeah.
Okay, I understand that, right? But now that was 5 months, and I didn't get a chance to get a bond until August the 4th.
Okay.
Able to bond out. So now my attorney advised me now that these cases here are not what hold me in.
Okay.
Right, but however the case may be, I wanted to try to get them all resolved as we spoke about.
Okay.
But at the same time, you know, I'm like right now, 4 months back in here with no bond status. My bond was revoked from my understanding. And here I am, and I was explaining to her my situation all the way around the board. You know,
Well, the good news is you have a permanent home now, meaning these cases are staying here. They're not going anywhere else. You got Ms. Rios working on them. She's mindful of the fact that you've been in for a while. She'll leverage that to your benefit if the state is saying, well, I don't know, he may need to do some time. He's been doing time, and you'll get credit for all that time. But to answer your question, I will see you next, either because Ms. Rios has filed a motion on your behalf to suppress this or that, or because she, after talking with you, has worked something out with the state and will be back here for you to enter a plea. If you're not interested in entering a plea, then we need to get you into court for a trial. I don't typically try shoplifting cases. They usually resolve. But if this is one where you're saying it wasn't me, or I paid for the goods or something like that, and the state's not budging, then we need to get you in here for a trial. And we'll do that. My guess is, though, what I'll see is that pretty soon Ms. Rios reaches out to my staff to say, can we put this on a calendar? Mr. Robinson's ready to resolve his cases.
ready to resolve it now. That's what I'm stating to it. That's what I'm basically stating to. I'm ready to resolve this issue, not even without the PI, even without the other case. You know, I would take my chances on basically. I got matter of fact, basically, Your Honor, sir, I've been feeling like I'm in a 440 relay. You were my 6th judge since I've been incarcerated on these cases.
Oh, it's more than a 440 then if you're on number 6.
So tomorrow, and then tomorrow I have another court date tomorrow.
For the PI case?
For the PI case.
Well, you got to stop getting arrested, Mr. Robinson. That's the deal. I mean, you can be flustered about you got these different judges, but you also got to do a little introspection and say, it's time for Mr. Robinson to stop picking up charges.
Taking accountability, I understand this.
Okay.
But I was explaining to her,
Well, Ms. Rios, is it your professional opinion that you ought to get the discovery first so you have a chance to talk to Mr. Robinson, rather than, hey, let's just throw it up and see what a plea looks like?
Yes, sir, and I explained to Mr. Robinson, and I was hopeful that we can get that PI case. I was actually just typing an email to send to Ms. Smith so we can get it all resolved in one time, because you're upset that you keep coming back, and I agree, let's get everything resolved so you don't have to keep coming back being done.
In fact, so you know, Mr. Robinson, when I learned that it was going to be Ms. Rios handling your cases based on the older of the two cases, the first thing she said to me is, and I'm going to ask prosecutor to go ahead and accuse that PI case so that we can get all three together and in one fell swoop say, now everything's resolved, as opposed to we'll resolve this one and you think, great. And just before you're ready to head out, you get grabbed by the ankle for your 660, your sixth lap, because you got that PI case. So give Ms. Rios a little time to get that discovery and to work with the prosecutor to see if the other case can be accused. And we'll bring you back in.
Months, we speaking of months or?
No, we're talking about weeks. Okay?
Yes, sir. Thank
See you soon.
Thank you.
Mr. Hines, tell me what update you've got on Miss Scott. I want to have her and her beautiful little kid not stuck in this courtroom much longer.
Yes, Your Honor, we appreciate that. I've spoken with Ms. Smith, and I believe she's going to make a recommendation to her office's diversion program. We know that, again, Ms. Scott has to be accepted into that, so we also talked about an alternate resolution, and we're both confident, I believe, that we'll have an answer for this case by the end of this month.
Okay.
As I've outlined, I have a scheduling conflict at the middle of April, but I also know Your Honor has a court date that I will be at April 2nd, so that's my personal.
What's the April 2nd date?
It's a final plea date.
Oh, for this case?
No, Your Honor, I'm sorry, just court in general.
Oh, okay, got it. And so your goal is to have lined something up, whether it is the district attorney's pretrial diversion program or some alternate that you and Ms. Smith agreed to, a series of conditions that would be diversionable.
Yes, Your Honor, and as always, I'll keep Ms. Nelson apprised of the progress.
Okay, I will backstop all of it with the April 23rd trial calendar. I hear you that you may be stuck in DeKalb, and so you wouldn't need to be here, but that's far enough out. April 2 is well before then, and we ought to be able to hear something from either the district attorney's diversion program or what you and Ms. Smith come up with, that maybe April 2 will be our magic day.
Yes, Your Honor, and also just for the record, I believe that if it is April 23rd, I can appear by Zoom because I'm sure the jury will just be deliberating.
Okay, sounds good. All right, Ms. Scott, you have any questions? Ms. Smith, anything else?
No, Your Honor.
All right, thanks. You guys are good to go.
All right, thank you, Your Honor. Good to see you.
Same.
Yeah. Avery.
Yes.
Avery.
Okay, then can we do Dodds? Because we've had Ms. Singleton stuck here. No, we can do Avery first. You said Avery. Ms. Rios getting a little pushy. Her one case, and it has to go first? Nah, I see how it works. You didn't offer to take Mr. Conley, huh?
Huh? You want to do a drug program instead then?
If they don't go for this, their task,
Probably not gonna go see. So do you want a drug program then?
Are we,
He would like us to reset because he wants me to see if he can do a drug program now.
okay. Mr. Avery, you have a couple cases with some probation left in both of them. You've got 4 years plus some change in one and 2 years and a little bit in the other, but 4 is more than enough. for drug court to work if you're accepted into drug court. I just needed to make sure there was enough time remaining on your cases. You were charged, one of the cases is a drug case. I have both here. They're both drug cases. And the allegation is more drugs and then maybe some family violence battery. But none of those suggest to me that drug court wouldn't work out. Have you received drug treatment before?
No, but I know I need it though.
Okay. The things I just mentioned suggest you might do well with drug court. So what we'll do, I guess, you'll do the outreach, Ms. Rios. You know how to contact the intake team.
Yes, I'll do the application today.
Okay. So Mr. Avery, someone from the accountability courts will want to meet with you. Be open and candid with them. It's a private conversation, but they're going to want to assess your need for drug treatment and the risks you face if you don't get drug treatment. So don't minimize things, don't exaggerate things, but say, look, I'm this age, I've been using these substances for this long, and if it makes sense, then, and they accept you into drug court, that'll likely be what then Ms. Rios advocates for as the way we handle this revocation, would be to revoke you into drug court, where drug court becomes a condition of your probation. And we see that all the time. And it often works out for people who are ready to get serious about recovery. And if that's you, then drug court could be great. Full disclosure, there are 2 drug court judges and I'm one of them. So you may end up working with me. That's just a coincidence. It's not because your revocation is here. They just alternate, one to this judge, one to that judge, so on and so on. So it may be that we work together if you are admitted into the drug court program. In the meantime, you got to stay put so that the intake team can meet with you. And as soon as we get that answer, Ms. Rios can let me know and we can get you back in here, okay?
All right.
Any questions about that?
Is it like, just asking, is it like, will I be able to work too?
You will. Initially, it's a little hard to do it because it's 6 phases. The first phase, you are in the drug court building during work hours much of the time. And so if you work, it need to be weekends or a night shift, but you can't sleep through drug court. Once you get to phase 2, all the way through phase 6 is more meet in the late afternoon or evening. And in fact, when you get to phase 2, we expect you to have a job unless you have a disability. So you're going to have to work when you get to phase 2. You may be someone who wants to be working right away because you need the money, because idle hands are a problem. And we encourage that as long as the work doesn't interfere with drug court. And as I mentioned, phase 1, you need to be at Hope Hall. That's where drug court meets in the middle of the day, a bunch of days during the week. So you need to find weekend work or evening work for that very first phase. Is that a problem?
It probably would be.
Okay, well, that's something to talk about with the intake team. Because if that won't work, if you're someone who, I'm making it up, but if you're an electrician and you got to be at work from 8 until 4, Monday through Friday, you can't during the first part of drug court. But then you're not treating what ails you, and you may go back to work, and then I guess we'll see you again in a different format. So you may need to make a few financial sacrifices. Do you have a place to stay, or would you need supportive housing?
I would want supportive housing.
Okay. So if we are helping with supportive housing for the first 90-ish days, tell me what the urgency is to, like, I got to get right back to work 9 to 5 every day.
Well, to be honest with you, my drug problem is more important than getting a job from 9 to 5 right now.
Okay. That says drug court then is important, and we ought to see if we can make it work out. And like I said, you may be able to find a little bit of a legal side hustle where you're working in the evenings or on the weekends for that first few weeks. And then once you phase up, you get to phase 2. What is it that you prefer to do for a living?
I was working with Pine Lake City, like park and rec.
Okay.
But that's in the daytime. That would interfere with drug court.
But there's no reason you couldn't try to go back there after you finish phase 1. If they like the work you did, you'll be coming back and you're going to be extra sober. So they should welcome you back. But we also have some job readiness programs and job networks you can plug into. So it may be you find something else to do.
That'll be fine.
All right, but talk with intake. No one's forcing this on you. It's a great idea if it fits your needs. So we'll see what happens.
All right.
All right, Ms. Rios, anything else?
No, Your Honor, thank you.
All right, Ms. Smith? You good? All right. Dodds?
I see that. Yeah.
Hey, Mr. Dodds, if you come on up to the podium, stand in front of the screen, please.
Okay, cool. Thank you.
All right, let's get on the record in your case, Mr. Dodds. It's 26 SC 000188.
Hold on, Judge.
Sure.
Okay, sorry.
All right.
Thank you.
You bet. Mr. Dodds, I'm Judge McBurney. It's nice to meet you. Your case has been assigned to me. And today you're working with Ms. Wood. Ms. Wood is a close colleague of Ms. Gordon. Ms. Gordon's going to be your lawyer going forward, and you may have met with her before. She's got a conflict today, but we didn't want to delay today's hearing. So Ms. Wood is standing in for Ms. Gordon, and we're going to do two things. I'm going to ask Ms. Wood if you're waiving arraignment or if I need to read all the charges, and then we're going to talk about bond. Ms. Wood's going to tell me why you should get a bond and what that bond should look like. Then I'm going to hear from the prosecutor, Ms. Smith, as to whether she agrees about bond or disagrees. I'll probably hear from Ms. Singleton as well, who you just nodded to. She may have some thoughts about bond, and her thoughts are also important because she would be providing the supervision in connection with any bond if you made that bond. And I'll let you know what I'm going to do, okay?
Yes.
Great. First, Ms. Wood, is Mr. Dodds waiving arraignment?
We will waive formal arraignment today, Judge, and I will get a waiver filed for him.
All right. Then let's talk about bond for Mr. Dodds.
Yes, Judge. So, first off, I think he's in no bond status right now. I didn't double check that because I couldn't see it on the jail odyssey, but I believe it's no bond.
He is. There was, bond was denied on the 25th of November by Judge Ashley.
Okay, thank you. So he's in no bond status. We are asking the court to consider setting a $10,000 bond to go through the sheriff's 10% program for this case. Your Honor, he is 16 years old currently. He's been in custody since November the 7th of last year, so right around, I think a little over 120 days at this point. He was 15 years old at the time of the allegations. Your Honor, for a little bit, I know we're not going to dive into the facts, but it was important for Ms. Gordon that I get some of these facts out there for the court to consider. So on the day in question, Mr. Dodds was meeting up with an acquaintance of his, who is the alleged victim in this case, to do a clothing swap. Mr. Dodds told the complaining witness they were not actually going to end up doing the trade because Mr. Dodds' pair of shoes were worth more than the shoes that the alleged victim brought, and the trade was called off. They went their separate ways. Everything was fine. Later on that day, the alleged victim started blowing up Mr. Dodds' phone. Mr. Dodds finally agreed to do the shoe trade, but he was going to bring a less valuable pair of shoes to trade with the alleged victim. Once Mr. Dodds arrived, the alleged victim had his shoes out, but then the alleged victim took Mr. Dodds' bag, and that's where the shoes were, and handed it to another person named Larry. And Larry at this point tried to take the bag and make a run for it. There was a tussle over the bag, which had some shoes inside of it. Mr. Dodds heard gunfire. He had seen previously that the alleged victim had a gun in his waistband. Like I said, shots were fired and Larry was hit, I believe, in the leg.
Larry is not the person with whom Mr. Dodds was going to have the shoe exchange. He's the bag grabber. After the shoe exchanger grabbed the bag, he gave it to Larry. Got it. And Larry gets shot.
That is my understanding. I believe he was, yes, accidentally hit in the leg. After all of this went down, everyone scattered and Mr. Dodds went back and got his brother. They returned to the scene to retrieve his bag. And so he did take the bag, and I believe the shoes were in it and another pair of shoes were at the scene as well. My understanding is a search warrant was conducted of Mr. Dodds' home. I don't believe a gun, no, police did not find a gun. So I know at the preliminary hearing, there was some testimony about an Instagram video that was at play. But again, we just wanted to get those facts out there for the court to consider. In terms of community ties, his mother and some other family members are here. Ms. Dodds, I've spoken with her out in the hallway, Your Honor. He would be living with Ms. Dodds. His grandmother also lives there. He also has 2 adult siblings.
This is on Triumph Circle? Is that the address?
Yes.
Okay.
He's a lifelong Atlanta resident, Judge, born and raised. All of his community ties are here. Before getting arrested, he was enrolled, he was a 10th grader at the City School of Atlanta. I did share some letters of support from the principal as well as the dean of students. I believe you may have received those today. They are vouching for him, said he does well at school, has wonderful relationships with all of his staff. We don't believe he's a risk to commit further felonies. I believe he does have 1 misdemeanor case in Clayton. I'm not sure. I hope Ms. Singleton may know if that one's still pending. I'm not sure what the outcome is of that one. He's also not a risk to flee. Of course, we are good with all the standard SB 440 bond conditions. And like I said, mom is very involved, Judge, eager to answer any questions the judge may have, the court may have. He's not a risk to intimidate witnesses or the victim. He has no reason to have any contact at all with any of the people that are involved in this case. And he's not a danger to the community. No issue with house arrest, ankle monitor, all of that, because he understands, Ms. Gordon has explained to him in depth that if he messes up, Ms. Singleton will file a warrant and he will be put back into custody. And lastly, he shared with me this morning that he is on the A and B honor roll. So we're very proud of that.
In custody or at City School Atlanta?
In custody.
All right. Mr. Dodds, City School Atlanta, is that an in-person or a virtual school?
Virtual.
It's virtual? So you were
No, I was
in
going-
person?
Yeah, in
Like
person.
you would go to a building and go to classes and had classmates and your teacher's right there. It's not on a screen.
Yes, sir.
Got it. And how, if you were 15, were you a freshman or a sophomore at?
Freshman.
Freshman. So that was your first year there?
Yes.
Where'd you go to middle school?
I went to middle school there too.
Oh, at City School Atlanta.
Yes, sir.
Okay. Got it. Okay. Thank you. All right. Anything else, Ms. Wood?
I don't believe so, Judge, not at this time.
All right. Ms. Singleton, few questions and anything you want to share. Can you provide the juvenile history for Mr. Dodds?
Yes, Your Honor. He has 1 prior case out of Clayton County for obstruction. It's from January the 17th of 2025. There's no movement on that case, so I wouldn't expect anything else to be going to happen.
Okay, so it wasn't adjudicated or whatever the verb is. It was presented and it's stalled out. Okay, and it's obstruction.
Yes, sir.
Got it. Okay. If Mr. Dodds were given bond and released on bond, would he be able to go back to City School Atlanta, or would he have to go through a program of APS, or that's really up to City School Atlanta? It's a private school and they make that decision.
Your Honor, my understanding of it is that his mom has stayed in close contact with the school, and so he is able to go back. I believe the name of it is City of Refuge. But it's the old Bright Futures Academy, so the City of Refuge is the school, and so they are welcoming him back from
Okay.
without a problem. He has a counselor that was going to try to appear today. I believe there was a larger group of people at his prior hearing, but he is able to go there without a problem.
Okay. Is that Ms. Reddick, the counselor?
Yes.
Okay. All right. So assuming, we'll call it City of Refuge, but the school, if they took Mr. Dodds back, you would still supervise him. It's just he wouldn't be in an alternative school or at an APS school. He's just at a school where he is, I don't know if you'd still be a freshman, but he'd be whatever he is, and then you'd be plugged in the way you normally plug in.
Yes, Your Honor.
Okay. All right. Thank you.
And I did want to clarify the address that he's supposed to live at. Is it the Triumph or the Washington Street? Washington Street.
Okay.
It was 1019 Washington Street, apartment 5. Atlanta 30315.
Judge, I'll get an address change in as well.
30315?
Yes,
Okay. What's at the Triumph Circle? Whose place is that?
that's where he previously was residing. That's where the incident location. So they had to.
Okay. Got it.
His sister actually lives at that address.
At the Triumph address?
No, at the Washington Street.
1019 Washington Street. Okay. Got it. Okay. Great. Ms. Smith, your thoughts about bond for Mr. Dodds?
Yes, Your Honor, in this case, the state will be asking that the defendant stays in the no bond status. The biggest concern for the state is that the state believes that the defendant may be a danger to the community based on the facts of the case. I know that the defense gave a version of what's supposed to happen, and although we're not here to determine his guilt or innocence, looking at the indictment we have in front of us with aggravated assault, armed robbery, someone getting shot, the state does believe that these type of offenses rise to a level of concern. And based on what happened, the state does believe that the defendant may be a danger to the community. Furthermore, we do understand that the defendant does not have a personal history of FTAs. However, the charges we have in front of us, they do run at a minimum of 10 years imprisonment, day for day, no parole. And we do believe that there is a likelihood that there may be a risk of not coming to court or to avoid prosecution based on just the minimum of what those charges could run. So based on the state's belief that the defendant is a danger to the community and that there may be a risk of him being a flight risk, we would ask for the defendant to stay in the no bond status. I think that one of the victims may be here in the courtroom, but I'm not too sure. If so, if they would like to speak.
Sure.
That's great also. If the court is inclined to give a bond in this case, we leave it to the court's discretion. However, the state does believe that this case should stay in a no bond status.
Okay. Do you want to check to see if there's anyone who wants to be heard?
Yes. I guess not.
Okay. Got it. Mr. Dodds, tell me what classes you were in at the high school.
I was in math, reading, language arts, and I was playing basketball.
Okay. What was the hardest class you were in?
I say reading,
Why do you say that?
cause it was just tough,
Yeah.
yeah.
How many students are there?
It like in the whole building,
Or in your class? Like
Oh,
if
yeah.
you were in reading, how many other kids are there in the reading class?
it like 8,
Okay. And in the freshman class, about 8?
yeah.
Okay.
Sure.
All right. Ms. Wood, tell me again who would be in the household at the Washington Street apartment?
I believe it's Miss Ivy Dodds and the grandmother.
And Ms. Ivy Dodds is mom?
Yes, she's right here.
Okay. And then grandma?
Yes, and then I think there's another,
And the person who raised her hand is sister? Okay.
and then I think there's another adult sister and brother that live independently, like Miss Singleton was referencing, so.
Okay, got it. And Ms. Dodds, do you work? What do you do?
I'm a custodian at Georgia State. I've been there 7 years.
Okay. And your daughter next to you, is she school aged or is she done with school?
She's not in school.
She is in school?
She done.
Done. And
She's 22.
okay, and does she work outside the home?
She works as well.
What does she do?
She's working at Georgia State as well, and nine.
It's a Georgia Tech family. Okay. All right. Okay. Mr. Dodds, is there anything you want to add?
Oh, sir.
Okay. Well, Mr. Dodds, I am going to set a bond for a couple reasons. But before I share with you those reasons, you need to understand that you're in a real serious situation. My guess is you figured that out because you've been sitting in a YDC for a long time. And now is not the time to screw around. So if your family is able to post this bond while you're out on bond, you need to lead a very boring life. No clothing exchanges. If there were guys you rolled with who are kind of flashy or tend to get the attention of police, don't. Just be boring for a while. Play basketball, do your hard reading, whatever it is. If you get sideways with the police, if Miss Singleton has trouble finding you or is getting reports from school, hey, Dodds skipped school or he got in a fight at school, we're done with the experiment of seeing how are you doing on bond. As I know I can find you if you're at the YDC. And I know you're not going to do another thing like this, whatever it was that happened, if you're at the YDC. But the YDC isn't the safest place in the world, and you're not getting the same education, and you're not there for your mom and your family. So we're going to try out bond. It's going to have restrictions, but you need to know that for a 16-year-old, life is going to be kind of boring while you're out on bond until you resolve this case. All right?
Yes, sir.
Is that clear?
Yes, sir.
Okay. Because if you screw around while you're on bond, the real easy fix is to say, we're done with bond and we'll just get you back to the YDC. You'll continue to get A's and B's, but it's just not the same world as being at school and being able to go home at the end of the day. You miss Thanksgiving, you miss Christmas, you turn 16 away from your family. And that's not how it should work. But you got mixed up in something where fortunately no one died. But the moment a gun goes off, it could end with, we're not talking about a few years or this or that, is life. So you just need to keep your head down until this gets sorted out. So I will set a bond. I got to spread it out across all these charges. So I'm going to set a bond of $15,000. It'll be through the sheriff's 10% program, which means the money that people put up, they'll be able to get back when the case is resolved. So they're making an investment in you, but they'll get that back when the case is resolved. A special condition of your bond is that you will need to have no contact with Larry Newell. That's the guy who got shot. As well as, I guess, Derek Wilson was the person you were going to be exchanging shoes with.
Yes, sir.
So you got to leave those guys alone. Sounds like if they are down near Triumph Circle, then they don't go to your school, do they? Good.
Sir.
So no contact with them. And then there are going to be a set of standard conditions that Ms. Singleton is going to state for the record about an ankle monitor and a curfew, and you can be away from home for school and doctor and things like that, but otherwise you're at home, staying out of trouble, doing your homework, and helping your mom take care of the household. Okay? Ms. Singleton?
Yes, Your Honor. The defendant would receive a 24-hour curfew except for school, medical, legal appointments, and anything else that is able to be approved by myself.
And that would include making this up, but if you made the basketball team, that would be really an extension of school. That if there's a game at 5 p.m., even though school lets out at 3, curfew would include, hey, you can play in the basketball game.
Yes, Your Honor, all extracurricular activities.
Okay.
Included and encouraged.
Yes.
That, he will be fitted with an ankle monitor that will be paid for by the Department of Juvenile Justice, and receive wraparound services paid for by the Department of Juvenile Justice, which is the in-home counseling. He just turned 16. However, if the defendant's case is still open at the time that he turns 17, that he would convert over to the county-funded ankle monitoring. Your Honor, that he would have no social media, no weapons, supervision by myself, and release by myself. Your Honor, and if we could add anger management on this case.
Sure. So you will need to be enrolled in a class about anger management. Ms. Singleton will help line that up, whether it's at the At Promise Center or through school or who knows what, but that'll be part of your bond conditions. And I'll tell you, Mr. Dodds, the one that Ms. Singleton said that's probably going to be the hardest is that no social media. That means you aren't messing with TikTok. I have a 15-year-old, and I think his head would explode if I said you can't be on social media, because he is always scroll. That's what he does. You don't get to do that, and you need to take that seriously. You may think like, all right, Singleton's not looking now. But if it comes to light that you're on social media, that's where we might need to lock things down and say, well, now you can't do extracurriculars. Or if it's enough, we say, you got to go back to the YDC. And it's not because we're taking some old person view that social media is bad for you. It's because that's where you make connections that right now you shouldn't be making. Where you're like, hey, I'm just scrolling, this guy's selling some sneakers and I like those. And then all of a sudden you find yourself in a situation like this again. So it's not a knock on social media. It's an effort to keep you from getting entangled in something that right now you don't get to be entangled with because you're facing these kinds of charges. Okay? Any questions about any of the things we've been talking about?
No, sir.
Ms. Dodds, do you have any questions? I'll make sure you understand he's going to be up in your business a whole lot because his curfew, he's home all the time. His sister's going to want to get out of that apartment, but that's a small price to pay to have him around for Christmas and his birthday and that kind of stuff. So I just need to make sure you're signing on for, yep, it's a curfew. I want him out of my house Saturday morning. He doesn't get to.
Thank you so much, Judge.
Okay, well, you can thank me by making sure your son does well under the conditions of this bond, because Ms. Singleton is very dialed in and she does not hesitate to say, Judge, guess what? Someone didn't come home last night. And all right, let's try 30 days at the YDC and see if that fixes things. And so we'll see. I hope we don't run into those issues. I know Ms. Gordon is going to work closely with Ms. Smith to try to get to the bottom of this. There are two sides to every story. Something bad happened because the gun went off, and we need to figure out how to sort all this out. I'll get that bond paperwork signed today, and we'll go from there. All right?
Thank you, Judge.
You're welcome.
Bye, Mr. Jackson.
And this is where I will end it for today. And we will continue this the next time Judge McBurney comes up. Because a lot of times she does 4 or 5 hour, 6 hour, 8 hour. Some of these judges do 8 hour live streams. So I try to break it up into, I want to continue doing that. Now, Judge Boyd might have a 3 hour. I'll go the whole 3 hours on the live stream to do it. Again, I want to thank all the new subscribers and all the subscribers to this channel, the mods. You all have been great. Thank you for your support. And if you're not a subscriber to this channel and you like this content, please do me a big favor and subscribe to this channel. And let's get this channel up past 500 before the end of this year. And I know we can do it because we have a wonderful, drama-free channel here, a community. Hey, Linda. Yeah, we got great mods here. We got great mods. It's something I want to touch on before I go. and that is the infighting between YouTube channels. I don't like it. I never have liked it. I never will like it. Look, we are all creators, and we are supposed to help each other out, not fight between each other. I think it's childish. I think there are some channels that are bullies. And I think it needs to stop. Just because you're a bigger channel than somebody doesn't give you the right to bully them. I don't care what you say about this channel. You know, I've been doing this for a long time, but on YouTube for a long time. So I know what's up. I just think that and I still don't get this. Why is the Two Fleas channel still hanging around? Technically, back in the day when I started as a YouTube channel, YouTube wouldn't tolerate that behavior. I just don't get it. But enough of me ranting. You know, this infighting. If you want to I will say this before I go. If you want to do the infighting bullshit, do not include my channel. We've been drama free. Do you realize how hard I worked to get this channel set up and running drama free? Do you know how hard I've been working for the last 6 or 7 months? I know drama brings views, but I don't want that here because I don't want the same thing to happen again. I still don't understand what happened. I still don't know whether I'm 100% to blame for everything that happened at the beginning of last year. I don't know. The only drama that's on this channel is going to be the drama in the courtroom. I know drama brings views. Yeah, drama brings views, but the drama in the courtroom will also bring views too. And that's why I encourage people: if you're watching this, please, by all means, share this out. Put this out there on the internet. You know, that's why I keep saying this every day, practically every day. Don't be afraid to share this out on the internet. Put it on your YouTube page, or put this on your Facebook page, or your X page, or whatever you use, TikTok, or whatever you guys use. Don't feel free to put that out on the internet. Let people know that I'm here, I'm doing this, and you're all welcome, except for those people that are banned. Those people will probably be banned for the rest of their lives. Because it seems that every time I turn around, there's some kind of drama going on between them folks. And I don't want it here. I know drama brings views, but so do the court stuff too. I did I can't remember what docket what judge it was, but at the end of the day, it had 98 views. Some of the stuff gets views, some of it doesn't get views. It depends. But that's going to be it for today, ladies and gentlemen. You all be good if you can. I'll catch you on the other side. I'll catch you on the next one. Ciao, ciao, and ta-ta, and I will see you guys tomorrow.
Breakdown, you're the one I call from the mountain. You know how to man all my scattered seams. With your steady hands, you refill my heart. Every piece that's lost gets a brand new start. You fix it all, fix it all. You fix it all. Daniel, you make it right. Daniel, everything's bright. When I'm falling apart, you put me back together. Daniel, you make it better. Fix it, Daniel. Fix it, Daniel. Fix it, Daniel. Make it right when the world shuts down, and I can't see clear. You're my solid ground, always drawing near. Never give up on this heart of mine. Put it back together every single time. Fix it all, fixing your album, standing tall to all you do. From the highest peak, I can see it through. With your care and touch, everything's okay.